We are going to move on to agenda items, update, review, discussion, and possible action on licensing and committee education committee meeting agenda. And I believe, Dr. McLean, you were going to start us out here.
This is legal, if I may.
Go ahead.
Yeah.
Can we take a roll call to make sure that all board members are present, please?
Sure. Mr. Ruffino, will you please take roll?
Dr. Paris?
Present.
Dr. McLean?
Present.
Ruffino present. Dr. Dan?
Present.
Dr. Azzolino?
Present.
And Dr. Adams?
Present.
Everyone is on the call, Mr. President.
Thank you, Mr. Ruffino. Thank you, Helen, for the reminder. And Dr. McLean, if you'd like to lead us out here.
Hi. The Continuing Education Committee met on September 18th, and we had a very good and productive meeting. We discussed changes to the mandatory continuing education hours and competencies. We discussed reducing the number of hours required under competency number 7, which is chiropractic adjustment and manipulation, which was suggested by one of the members. Ultimately, the committee decided to maintain the 4 hours that we previously had discussed, unless and if there's further supporting information to substantiate the reduction of hours, and that is brought forth, and if the board itself as a whole would like to discuss that further at the end of my report here, we welcome that. We also discussed the content changes in competency number 5, professional ethics and jurisprudence. The goal of the committee is to strive to reduce disciplinary actions by utilizing continuing ed courses to educate licensees about top enforcement. And so that's a very important aspect. We, as a committee, also began discussions surrounding defining classroom courses versus distance learning courses. We reviewed synchronous learning. We made progress in this area. However, we still feel that an in-depth discussion needs to be continued to further to properly define the distance learning and make some more progress there before completing that task. We discussed the proposed language and policy changes as it relates to CCR section 364 to 366. The committee members as a whole agreed that adding a stipulation authorizing the board to make necessary changes to the CE requirements during national and local states of emergencies was prudent. And we considered these changes considering the present challenges that COVID-19 has caused the board as well as all boards, I believe. The staff will follow up, however, on a variety of issues that we still feel need to be vetted, as well as one that was brought up previously was expense of technology for timekeeping and online classes, et cetera, because we still have some in-depth conversations that need to be had in order to complete that topic. We've had some valuable and substantive discussions with stakeholders at this particular meeting who were present and very engaged. And I feel we had one of the best meetings I've ever seen in relation to attendance and positive productivity and engagement from stakeholders. And I, for one, really welcome that for anyone listening today, that I feel that, again, that this is how it should be done. And we are very thankful and grateful for those who participated. They brought forth some information. They volunteered to bring forth more and to help resolve some of the challenges that we feel that we might have in resolution. So I think that's it from if I'd like to ask Natalie if she had some additional input.
Thank you, Dr. McLean. Not too much more of an update than what was provided. The committee is set to meet again soon. It has been posted for the public. We're hoping to have, again, robust participation on November 6th. And then again, we'll be discussing in depth the distance learning definition. And there's been some new waivers from the Department of Consumer Affairs that can really lend our discussion and hopeful decision making for that topic.
Fantastic. I will turn it back over to you, Dr. Paris, and I'd like to see if anybody have any questions, comments, concerns, or discussion.
Thank you, Dr. McLean. Any questions or discussions from the board? While we're waiting for someone to jump in there, I would like to say that was one of the most engaging calls that I've been on since my brief time on the board, and thank you both for leading that. And I hope we have more calls like that into the future. So thank you. Looking forward to the next one.
Sorry, I was muted a bit earlier. This is Marcus. I just wanted to be clear.
Marcus, you're breaking up. I don't know what the problem is.
We're referring to a definition of distance learning in light of some.
I can't hear him.
Marcus,
Can you hear me now?
you're breaking up for us.
Oh, no worries.
Pretty bad.
No worries. Okay, no worries.
Do you want to switch microphones, and we'll give you a second?
Apologies for that. I just wanted to provide a little bit of clarification for a comment that Natalie made. I think she was referring specifically to what she said about the definition of distance learning. I think in light of COVID, I think we want to make it clear that we want to have a robust discussion about how to define distance learning in light of, shelter in place and the ability, and also in relation to 24 hours of continuing education and whether or not it's a reasonable option for licensees to be able to complete 24 hours of CE distance learning versus the current model that we have in place. And so that will be something that will be discussed at the next licensing and CE meeting.
Thank you, Marcus. Is there any other discussion from the committee? From the board, I'm sorry. Board or the committee? Okay, great. Natalie, Dr. McLean, anything to add? Anything else?
None for me. Thank you very much.
Same here. No further updates. Thank you.
Okay, moderator, can we please open it up for public comment on agenda item number 10?
All right, this is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this agenda item, please click on that icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. I'll now pause a moment to give members of the public time to access that Q&A panel and submit their requests.
Sarah, there's somebody on the call who needs to be unmuted to speak. I don't know, because I believe he's calling in, or he may be on the WebEx. Name's Brian Ota.
Unfortunately, I don't see a Brian on the call. Give me 1 second to check the participants. I also don't see a Brian in there either. Because our call-in user 12 is Mr. Ruffino, and call-in user 20 is Marcus, and I don't have any other call-in users.
He just texted me that he was on the call, but muted. Dr. Oda, if you can hear me, if you can send me a text and let me know what number you're calling in from, or yeah, I don't know what the, well, let's go ahead. Is there anybody else while this is open that has public comments?
There are no requests right now for public comment. Would you like me to go ahead and close that feature?
Yes, we can come back if he gets on.
Sure.
All right.
Okay, so if we can move on to agenda item number 12, update, review, and possible action on revisions to AB 2138 regulatory language. And I'd like to welcome Mr. Clay Jackson, the attorney in DCA's regulations unit. Mr. Jackson, are you on?
I am. Can everybody hear me?
Yes, sir.
Great. All right. So if everybody can turn to, let me pull it up here. Everybody can turn to item 12 on your agendas, which is on, find the right page, on page 106 of the packet. Then I'll review everything with you. Since there is the outline in your board packet on updating and explaining why this is going on, let me just give you a quick update for those that weren't able to review the package. Essentially, this is AB 2138, which the board previously passed last year, and the process was going ahead, as you were advised then, where DCA Legal had met with OAL and the Attorney General's office in order to put together a template that would hopefully sail through OAL without a problem. OAL's Office of Administrative Law for the new directors, and everything was going fine. We at DCA Legal had a test package that was the first one to get out of our office, which was VetMed, and we thought it was going to sail through. And then 3 days prior to its passage of its 30-day timeline with OAL, our office was advised that there were numerous changes that would be made to the template and to VetMed's package, and those changes ended up causing VetMed to withdraw their package last November. It took about 2 months to get revised language through, with VetMed passing their language, and then in February last year, we thought everything was a go again, and it ended up that COVID hit and threw OAL for a loop with all of the emergency packages that they had to put through for COVID. So VetMed's package, instead of going through last November, ended up not being submitted to OAL until June 2020. Then because of some revisions at the Department of Finance and the way they want their information to be listed and what information needed to be listed, it became necessary for OAL to invoke their 2 COVID waivers, which has allowed VetMed and every other package that's been submitted to have 120 extra days for review, not just 30 days for review. And the last part, I was hoping to be able to tell you that we had a package that has made it through OAL and Department of Finance, and we're still waiting for VetMed along with 15 other packages for AB 2138 to go through. In looking at the text that were sent, these modifications that are highlighted in yellow are the specific ones that I'm trying to share my content here so you can see my screen. OAL has requested, and is it possible to share my screen at this point? It's not letting me.
This
Moderator,
is the moderator.
can we please?
Yeah, let me pass over presenter role to Clay.
Awesome.
All right. Should be... Okay, you should
Okay,
have presenter
wonderful.
status now.
There we go. Can everybody see AB 2138?
Yes,
and
we can.
the regulation? Okay, great. If you look at this, make it bigger so we can all read it. These highlighted portions in yellow are the revisions that are being proposed. These were all, as I said, revisions required by OAL. And so I can discuss them specifically, but most of them were for clarity. OAL did want other items such as professional misconduct stated here. Again, for the new board members, professional misconduct is not an OAL phrase, or it's not an OAL phrase. It's not a DCA phrase. It's a phrase used mostly for attorneys. As a matter of fact, when I first started reviewing these packages, when I was hired last September, I was looking at these packages, and I'd never heard professional misconduct used in a context of a DCA board. So when I went and looked it up, it's not used by DCA. It's used for attorneys, and so somehow it got slipped into 2138, which then got slipped into all of the DCA regulations. And DCA uses unprofessional conduct and not professional misconduct. So essentially, all of the DCA boards have had to go through and then change their regulations to include this sort of thing, which is why it was added here, so that in order to state professional or unprofessional conduct as a ground in creating what a substantial relationship is, it became necessary to include the unprofessional conduct section of the Act, the Chiropractic Initiative Act, whereas had it just said unprofessional conduct, we wouldn't be having a lot of the revisions that you're seeing here. The only other item is we'd added a crime or act of child abuse instead of conviction of child abuse, so AB 2138 does focus on convictions, whereas previously, if there was an arrest, that would have to be disclosed. And so the proponents of AB 2138 were, I think rightfully so, very adamant in requiring convictions and not arrests, since being convicted of a crime or an act are what the Constitution requires, and arrests, since pretty much anybody can get arrested for anything, that's why convictions are being used throughout this section in creating what is being looked at. as I said, the new item for that is just as of about a month ago, in reviewing the revised package from that's going through at OAL, some of the OAL reviewing attorneys focused on the words violence. So it just said conviction for assault, battery, or other violence. And so they were saying, well, violence to who or what? Violence to a person, violence to property, such as losing it while you're driving and taking your crowbar and smashing in someone's windshield. Is that the violence that's being discussed? And so, or is it violence to an animal? And because of that vagueness, some packages include this, some do not. Some boards like having very specific shopping lists, as I call them, so that when a licensee is wondering, what does this mean, they can look up something and have a list of items that are included in what the board would consider violence. So I like this list. This is a penal code section specifically related to health practitioners, which chiropractors are. So I went and just so that you'd be able to see what 11160D says. I like this list because it's not vague at all. It's very specific as to what assaultive or abusive conduct would be in a healthcare situation. Murder, it provides the specific penal code sections for each of these crimes, so that there's no more vagueness as to what somebody means if they say, well, violence is manslaughter. It's violation of these sections. And so all the way down the line, mayhem, torture, assault with intent to commit these crimes. And so this, in my mind, is very specific, and although it's very long also, because there's a lot of things that could be deemed to be violence. So in looking at just going down the list, by including this last phrase, the board would be specifically saying, if you commit any of these acts, we will consider it to be violence, which is substantially related. That's what the board will be using in determining whether these crimes or acts are substantially related to the licensure or to denying or taking action against someone's license. So once again, here you'll have violence, including that list that I just showed you. And if anybody wants to go back to the list, please let me know. Most of these are items, once again, that are making it more specific, and also more clear. One of the tests, there's 6 items that OAL looks at, and again, it's a shopping list of what they're looking at when they are reviewing a document and a package, and clarity is the one we see the most. If they can't understand it and they're attorneys, then they figure no one else is going to understand it, which is a reasonable item. These marked in purple, at least on my screen, are items that Robert and Marcus and I discussed. So we added them here once again for clarity, so that when someone's looking at this, they'll be able to better understand what is here. This section for rehabilitation, criteria for denials, restatement, and reissuance of a license is somewhat different than, and this is a new section, is somewhat different than the following section, which is rehabilitation criteria for suspensions and revocations. And the big change comes down in B1. It adds disciplinary actions or crimes or acts where that is not found in 326. So, and all of the strikeout here, when I was going through making the revision, all of these revisions, what I was noting was that this prior language that the board had done that I've highlighted, this prior language was hard to work into the new vet med language. So instead of, I tried, it was like a Rubik's Cube. I kept turning it and trying to make everything line up. And then I just decided the easiest way to make it line up is get rid of it and start over, which is why I cut it out here. And then I just put it back in here as new language as new language, or actually I put it in up here as new language. So the language is now consistent internally, and that also makes it consistent with what OAL is looking for from the vet med changes from last December. That's all I have at this point.
Thank you, Clay. Are there any questions or comments from the board?
Thank you very much, Clay. This is Sergio Azmelino. In looking at this, if we look at section 326, section B, it says if the applicant or practitioner, if the applicant or petitioner has not completed the criminal sentence at issue without a violation of parole or probation, or the board determines the applicant petitioner should not make the showing. I'm just curious about the mechanism here. I understand what the spirit of this entire legislation is, but my understanding is this is a decision made by the executive officer to deny, or does it come before the board? How exactly will that work in our case?
Well, the actual function is probably better discussed by Robert, but the bottom line is nothing in the manner in which the board hears these would be changed. So if on an application or on a petition, that procedure wouldn't change. It's just the information that the board would be reviewing would change. And a big part of it is I sat in another board's hearing on it was a hearing so that a person could regain their license, and this person was 55 years old or so, 50 to 55 years old, and prior to that, my mindset was, if you do the crime, you do the time, and you've got to accept whatever is there. But they were asking this lady in an open session, which is appropriate. They were asking her about a crime that was a drunk driving that she had when she was 18 years old. It was a drunk driving conviction from when she was 18 years old. And that was when my eyes were opened up, and I kind of saw for the first time, wow, this is somebody that's got a 30-plus-year-old crime, and it was a conviction. It was a good conviction, but they were bringing it up from 30 years previously, and following her loss of her license, this woman had essentially gone for sainthood. I mean, she was volunteering in all kinds of programs. She had gotten her a master's degree in a completely unrelated field, and was only going to get her license back, essentially, in my mind, just to get her license back so she wouldn't have that scar on her professional record. But that's the kind of thing that all of these laws together would allow. It wouldn't change the way the board sees it, and I don't believe it would change the way Robert and the staff would review these. Would you agree with that, Robert?
Yes, I would.
Does that answer your question?
It doesn't.
In what way doesn't
sorry,
it answer, Dr. Azzolino?
I was having some connection difficulties. So it does answer from Clay's perspective, but from your perspective, Robert, you would be the one making that decision, correct? Or somebody in your capacity?
Correct. It would be me or my successor, should I leave. And we still receive information, and, it's what we take into consideration. We have to look at, like, if we're talking about an applicant, we have to look at their application collectively. So, so something similar to the case that Clay was speaking of, where somebody way in their past had a DUI or some other minor violation. Right now, we wouldn't deny them based on that, and not to dismiss a DUI as a minor violation, but something that isn't indicative that they wouldn't be a good licensee. So we would be aware of that, but that in and of itself, we wouldn't deny a license. Now, if they had a whole series of DUIs and other offenses, then collectively, we would look at that and most likely deny, if they, especially, if they have more recent violations. So I don't see a lot changing, and we haven't seen any changes. We haven't had situations where, since this law has been enacted, where there's somebody who we had serious concerns about, but our hands were tied and we weren't able to deny. So yeah, not much will change, and the process won't change, because I will still, or whoever's in my position, would still review all the facts and determine whether it's appropriate to deny a license. And then it would ultimately, if I entered into a stipulated settlement with the individual, for a denial, it goes for a statement of issues, and then I might stip, or it might go to an administrative hearing, but the decision would ultimately go to the board. So either the stipulated settlement or the administrative law judge's decision would go to the board to adopt or non-adopt.
But it would only go to the board if you deny. And correct?
Only if I denied. But it's again, in all likelihood, because this regulation doesn't include serious violations, violent violations or sexual violations, or convictions. Those wouldn't be subject to this, and serious violations and more recent violations. So in reality, there's I don't see anything that we would currently deny that we would not be able to deny going forward.
And I just highlighted those, Robert.
Yeah, and
I'm sorry, Clay, what was that?
I just highlighted those on the screen for everybody to see.
Oh, thank you.
Thank you, Clay. And I'm fully trusting the process that we have now, because I believe we have some very reasonable people aboard, and we've not done that, Clay. We've not issued a license or penalized anybody for such past wrongdoing that they've been fully rehabilitated. My concern is quite simply just that I don't want to lose the ability for the board to have some discretion over these situations. And as much as I trust you, Robert, and we hope that the next person who is your successor has the same reasonableness, but what do you think about having a committee or something of the sort where these issues are looked at? Because if you deny it, it'll go before an ALJ and come before the board, but one may loosely interpret this new regulation and people may get through that really should not have been issued a license, as the case that I recently brought to your attention, where as an individual that performed insurance fraud, and he didn't get licensed in California because of our current situation, but he got licensed in a neighboring state and just didn't disclose it. So, isn't it reasonable to have maybe a licensing committee, not of the public, not of the professional members maybe, but just of staff, where everybody looks through a situation like this and has to weigh in?
Well, if you're speaking of, because of course board members would be precluded from participating in anything prior to deciding on a decision, but staff are already. When I say that I approve or I deny or don't deny, that's based on the recommendation of staff. These matters are reviewed by experienced licensing and enforcement staff who do this, and they know what the criteria are and what the law is, and make a determination that we should deny or grant the license, or we should take discipline or not, and then that comes to me as a recommendation, and I make that decision. When we're talking about disciplinary matters, it's it's often in conjunction with legal counsel, and so it's not done in a vacuum. And so I'm confident that whoever, we keep talking about me leaving, but I'm not at this point. But if I'm not here and somebody else is in my place, I'm confident that person will have the knowledge they need to make these decisions, and will have the same resources that I have. The department and the board staff and Department of Justice, there's a lot of resources that I rely on in making those decisions. And if somebody did they made an erroneous decision or something, if it became, it would get addressed eventually. That's something EOs aren't able to run amok and make decisions that the board wouldn't agree with for very long before the board finds out, and then, or the
but how would we
department
find out,
realizes there's a
Robert?
problem.
How would we find out? If you issued a license, as the process works right now, in my opinion, it's working quite well. And my only concern is just looking into the future here with this AB 2138. It really takes away some of the discretion of the board. And so if we do have somebody run amok, how would the board know? The board will not find out if we have somebody that previously had one of these infractions or convictions, and they are issued a license.
In my experience, if I make a decision that the profession or a stakeholder is not happy with, the board finds out. And so they, people, especially when you're talking about people's livelihoods, if I don't take that decision seriously and I just arbitrarily deny somebody, it's going to get challenged. There'd likely be litigation. There would be people complaining to their legislators or to the department. And if it's something involving an existing licensee, they would be going to other members of the profession, and members of the association would be emailing board members and say, what the hell's going on with your EO? So anything can happen. You could have the wrong person in a job and they can make erroneous decisions, but it won't go on for very long. And
okay, I'm sorry, I didn't make myself clear. I'm on the opposite end of that. I'm not worried about you denying things. I'm worried about somebody squeaking through because of AB 2138. So I'm worried about somebody that is a convicted criminal getting their license because somebody believes they don't have authority to not deny it because of the revisions of 2138.
Frankly, that could happen now. It's like if I were corrupt, somebody could offer me an offer I couldn't refuse and say, let me get my license.
On a public board meeting.
I'm perfectly aware that that the public can hear me, and but that could happen now. There's nothing to stop me from doing something inappropriate, but I'd like to believe I wouldn't get away with it for very long, and somebody else in my shoes would also, if they were inclined to do that, it wouldn't last for very long.
Okay, well, my intention here was not to suggest anybody was corrupt or would be corrupt. I'm trying to protect those individuals that may think that they do not have the authority to deny because of AB 2138. So it's more so I trust everybody at the board in the process right now, and I want to make sure that there's a system of checks and balances, that they don't feel like they're being overpowered by the legislature because of some some law that was passed. Does that make sense?
Yeah, that makes sense. And, we will, I have confidence that, if I ultimately leave, that there will be, that I would have groomed somebody to step in and who I knew would do the job well, or that the board would have a good candidate pool to hire somebody who has the ability to make these decisions and to understand their resources and go to them to find out if they're making the appropriate decisions. So, because there's 40 some odd regulatory programs within DCA, all in the same boat, all subject to this law. And so it's something that, if it were a problem, it would be a problem across the board.
And so on that level, thank you. On that level, Clay, I still have question why each individual board, when we deal with the healthcare specialties, has to have these separate provisions. I would think that they should be fairly uniform across all healthcare specialties.
Which we, DCA legal, that's why we went to great pains in drafting the template that we'd hoped BetMed would take across the finish line, and we're sitting here a year later next month, and we still don't have a package approved. But all of our packages look substantially the same. The only place where they wouldn't be the same would be the shopping list, the one I mentioned before, just this shopping list right here, that some boards didn't really like the shopping list idea, and they just kept it really brief. But last year, your board decided that they wanted to have a list that identified what specifics the chiropractic community would be looking at as it says here, for purposes of knowing what a substantially related crime, professional misconduct, or act shall include. So that's really the only change between the various professions, regulations. Everything else is pretty much the same. And I did highlight this down here if anybody was wondering why I'd highlighted this part. This is what Robert would be looking at and what the board would be looking at in making a determination whether rehabilitation had been completed or not. So you're still looking at items such as nature and gravity of the crime, the length of the parole, the extent the parole was shortened or lengthened. And these are all substantial factors. And the only other thing I'd want to bring out is rehabilitation is an actual certificate of rehabilitation. Before I took on 10 of these and needed to look at it, I actually looked up what a certificate of rehabilitation was so that I could properly advise all of you. And it's not just something that's handed out at the prison gate to members.
I mean, he represents.
These certificates, the certificates require a lot of work on behalf of or on the part of the person, whether they be an applicant or a licensee or a prior licensee. They take a lot of effort on their part to obtain. And when I was looking at it, I thought, wow, it's easier to get the governor to overcome your crime than it is getting a certificate of rehabilitation. So that, to answer your question to Robert, how do you know whether these people are appropriately vetted and they're obtaining a certificate of rehabilitation is something that's that's hard to get, and it's not, like I said, it's not handed out when you get out of prison. So I think that would answer your concerns also.
Yeah, thank you.
Thank you, Clay. That was extremely detailed, thorough, and the background on all of that was really, really helpful. That was great. Thank you. Are there
Thank
any? Yeah, thank you. Are there any other questions, comments regarding what Clay presented?
Hi, this is Lawrence. I do have just maybe a clarification from Robert regarding the conversation you were having with Sergio and the decision you might make. You know, the denial is one thing, right? And that always can trigger, you know, an appeal and those types of things, which would then come before the board. In the event that an approval, would we hear about that after, like, say, at the next meeting, that these were approved? These individuals that petitioned were approved to have their license, and these were the grounds they satisfied, so that the board would be in the loop on that, or we just never hear about it, period?
Correct, Dr. Adams. So as we did earlier in the meeting, when we approve licenses, all new licensees need to be approved by the board pursuant to the law. So when we approve licenses at the staff level, then you get a list, like I don't remember what agenda item it was, but one of the first agenda items was ratification of approved licensees. And so then you would see a list of all of the licensees that we approved for licensure, and then vote to approve them. That wouldn't let you know all of the details that we saw when approving their license. You know, that tells you that they met the criteria as far as educational and training criteria and passed the appropriate exams, and you would presume that, you know, don't have any criminal convictions or violations that would preclude them from licensure. But so you do have a list. Now, if you happen to be aware of somebody who you knew of that had been convicted of, you know, insurance fraud or armed robbery or something, and you see their name on that list, then you could raise questions about that, subsequently. But you do know who we approve. Every new license applicant or new licensee, the board sees the names.
Thank you.
Does that answer your question?
Yes. What just for one clarification though, does that list that we did, that was new licensees? I'm assuming those are, you know, people that have just graduated from chiropractic school and are seeking licensure within the state. Is included in that list are people that are reinstatements as well?
No. Well, reinstatements go before the board. That's not a decision I make. The reinstatements, they apply, and there's really the criteria for, they have to wait 2 years from when they're revoked, and meet certain CE requirements and so on, and submit payment. And so if they meet those criteria, then we would approve them to petition the board for reinstatement, and they would appear at a board meeting, and so then the board would make the determination and would be provided with all of the documentation that we have available on that licensee to make that decision. And it happens, you haven't had the opportunity to participate in petitioner hearings yet, but soon you will, and you'll see how that process works. Now, if somebody was in another state licensed and had convictions, and then they applied for licensure in California through reciprocity, you would see that name along with the new applicants who had just graduated from college. So any person who receives a license or is approved for licensure by staff would have to be ratified by the board.
Thank you. I appreciate that.
Dr.
No
Adams,
nothing
just to be
further.
clear, Dr. Adams, and I don't know if Robert said this, but there will be no distinction made on that list, to my knowledge, between how those folks achieve their license, whether it's a reciprocity or the regular pathway, right, Robert?
No, I don't believe so. It'll just show their name and the license number issued. So you wouldn't
Yeah,
know if they were right out of college or if they had been licensed in Nebraska for 20 years. You would just see that they're a new licensee to the board.
Or if they appealed an initial decision to deny a license and were thus granted it at some point later. You wouldn't know that either. I just want to make that clear so you know.
Yeah, well, they would, because if they appealed, if we denied and there was an appeal, if there was a statement of issues, and then ultimately through a stipulated settlement or through an ALJ decision, the license was granted, then it would go to the board to adopt or non-adopt. So the board would know about those people.
Oh, I just wanted to be clear that the list that they ratified doesn't make a distinction. That's all I wanted to make clear.
No, it won't. But the person who appears on that list who had been denied and then ultimately got their license, that would have been through a process involving the board. So the board wouldn't see that, yeah, this person was denied and then appealed and you ultimately approved them getting their license. Because usually if they're denied and then they get a license, it's usually a probationary license, but that would have been a board decision. And so then when they see the list, it wouldn't be specific about the path that person went through to get the license, but it would nonetheless show that they were licensed. Does that answer the question?
I'm not sure who that was. This is Lawrence. I'm not sure who that was before talking, if that satisfied their question. So just for my clarification, Robert, it sounds as though when somebody's petitioning for a license, just like when I got my license, I had to answer questions whether I had been convicted of a crime and blah, 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 blah. If the person checks that box, that's really what you're referring to here, is that then you would, before it ever got to the board, determine whether their conviction rose to the level where it needed to come before the board, or you would have to deny. Isn't that really what this is about then?
Correct. If somebody, because not only do you have to self-declare if you've been convicted or arrested, but we also, as you know, all licensees are fingerprinted, and we get criminal background information from the California Department of Justice and from the FBI. So if somebody has a criminal history in the United States, at least, we would get that information either directly from them and or from the criminal background check. And so then we would determine, is this grounds for denial? And if it was a DUI 20 years ago when they were 18 years old, then most likely that we're going to approve that license, and the board wouldn't know that we did consider a violation and ultimately granted the license. But if it was something more significant where we wouldn't approve the license, then it goes through the process because we deny, and then more often than not, more often than not, they will appeal, and then there's a statement of issues, and then it's a process involving the board. So the board would ultimately, when a decision's made, the board would approve that decision or non-approve.
Thank you very much. Now I'm much clearer about it now. Appreciate it. Thank you for your time.
You're welcome. My pleasure.
Are there any more questions or comments? Okay, I'm gonna do this a little differently. Is there a motion to approve the proposed regulatory text for Title 16 CCR Sections 316.5, 326, and 327, and direct staff to submit the text to the Director of Consumer Affairs and Business, Consumer Services, and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to amend the preceding rulemaking package, initiate a rulemaking process, make any non-substantive, technical, or grammatical changes to the package, and set the matter for hearing if necessary. That was a question mark at the end of mine. Is there a motion?
That actually is the motion. So if somebody wants to make the motion, they can just say yes. They don't have to say what the motion is, and then that'll be the motion on the floor. And that's in the packet, so everybody can see what the motion says. And
I've highlighted it on the screen.
Thank you.
Thank you, Clay.
Thank you, Clay.
It's Dr. McLean. I will make that motion as stated previously.
Thank you, Dr. McLean. Do we have a second?
I'll second.
That was Dr. Dane?
Yes.
Thank you, Dr. Dane. Is there any further discussion? Hearing none. Mr. Ruffino, will you please call the vote?
We should probably ask if there's any public comment on this specific language before you vote on the language.
Okay. Moderator, can you open for public comment on the specific language in this motion?
And this is just on this this regulation, not on any of the other licensing committee matters.
All right, I'm going to pass over the presenter status to my co-moderator real quick, just so we can get those instructions up on the slide. So let me do that. All right. And at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on that specific item, please click on the icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. I'll pause a moment to allow public time to access that Q&A panel and submit their requests. All right, this is the moderator. It looks like at this time there are no requests for public comment. Would you like me to close that Q&A feature?
Yes, please.
All right, and would you like me to give presenter status back to Clay?
I don't think that's necessary. Clay, you can speak up if you think you may have more comments, but once the vote is taken, I think.
Right. I don't need it.
All right, sounds good.
Okay.
Thank you.
Thank you, Clay.
Thank you.
Hearing no further public comment or discussion, Mr. Ruffino, will you please call the vote?
Yes. Dr. Perez,
Yes.
Dr. McLean,
Yes.
Ruffino, yes. Dr. Dan,
Yes.
Dr. Azzolino,
Yes.
Dr. Adams,
Yes.
motion carries unanimously, Mr. President.
Thank you, Mr. Ruffino.
Back to let them.
So I think we're if it's okay with everybody here, we are going to jump back to. Did we have the public comment?
Yeah, we had the public comment for licensure, and there was somebody who wanted to comment but was having connection issues. And we did get them connected, and I believe they're still on the line. So I wanted to give that person, Dr. Oda, a chance to make comments on the licensing committee if he still wishes to do so.
All right, this is the moderator. Dr. Oda, I'm going to unmute your line now.
Thank you. Can you hear me now?
Yes, we can.
Great. Thank you for allowing me to speak before the board today and taking into account my schedule. I'm working this in between patients here. My name is Brian Ota. I'm a chiropractor working in Silicon Valley. I am the physical medicine program director for a company that employs 14 physical therapists and 13 chiropractors in 8 San Francisco Bay Area locations and 3 out-of-state locations, all of which are on corporate campuses. I would like to propose an update or an amendment to the current CR&R Article 1, Section 308 surrounding satellite licensing. Specifically, quote, any licensed doctor of chiropractic with more than one place of practice shall obtain from the board a satellite office certificate for each additional place of practice, unquote. In the recent few months, a situation arose related to COVID where it was necessary for all of our chiropractors on staff to practice out of an office other than the one that was listed on their main license. We also knew that we would probably have about a week lead time from when the light turned green for us to go on this big project. It was quite an undertaking. Understanding that the turnaround time for the request of a new satellite license is about 3 to 4 weeks, it became a concern that our new project would be delayed if we wanted to stay compliant with the CR&R. Fortunately, the board was willing to work with me to process 11 satellite licenses in less than a week and get everybody running and compliant on time. It enabled us to launch our new sites and to get everybody where they were supposed to be and in line with the board regulations. So thank you to the board for helping me through that and the guidance on this issue. It would have been a mess if we didn't have a little help from the board, actually quite a bit of help. The inability to acquire a satellite license quickly potentially could hamper productivity and delays in moving providers around the campus as needed in a situation like this. Sometimes we have very little notice, like in this case, where each provider was going to be working, so we couldn't apply for them early. Projects could be late and patient care could be affected for up to weeks at a time. This type of group practice with multiple locations and multiple providers is a growing field for chiropractic, and I feel like this is one that we should try to promote because it's really good for the profession. It instills the ability to work in a multidisciplinary setting, which is what we have, and it really enhances the credibility of the profession. The amendment of this regulation would make it easier for these companies to stay compliant, productive, and flexible. A possible solution would be to grant something like an umbrella satellite license to the employer with all of the employees listed and all of the potential locations listed, allowing any of the employees to work at any of the sites that are listed for the course of that renewal year. Some of the logistical issues like fees, renewal dates, et cetera, would have to be determined based on the practicality. That's not something that I'm versed in, so I would lean on the board a little bit for guidance on that. I really just wanted to put this on the radar, and hopefully the board will consider moving forward with a change to the regulations on this, and I'd be happy to return at a later date for another meeting that we can get this on the agenda. Thanks again for the time, and let me know what I need to do to move this forward.
Thank you, Dr. Oda, for your comments and your suggestions. So I'd like to also allow Dr. McLean, we had planned to do it in agenda item 10, but we shuffled on too quickly. So as I mentioned in my opening report, we're engaging with stakeholders in the broader chiropractic community, and Dr. McLean had attended FCLB meeting as our delegate, and so she'd like to give us an update on that. Dr. McLean?
Hi. Thanks, Dr. Paris. Yes, I think Dr. Paris and I attended FCLB on October 7th and 8th. During the FCLB meeting, there was also presentation or reports given from the MBCE as they work collaboratively together, and to the extent that 2 members of the FCLB are automatically become board members to the MBCE. The MBCE reported that as of August, that they were all caught up with those needing to take Part 4 exams. that had been pushed back secondary to COVID, which was very, I'm sure, very much needed, or very, very made a lot of students very happy. The NBC also reported that they always desire to have state board members assist them with administrating their tests at various locations. I think both David and I think maybe Heather, are going to be um, going to assist in the next part for exams. On the first day's topic was regarding management excellence, and they spoke at length about boards and recommended that boards do a regulatory assessment, possibly as a part of our strategic plan. But um, reported that it should be more along that it's necessary to have ongoing metrics that we evaluate not just the number of complaints and the response time, but that we go deeper in how and in analyzing how what we're doing is changing the complaints, and ID areas that we can think about that have a causal connection. And I thought that that was something that we really should further discuss, because that's the whole purpose, for us to not just look at the numbers, but how we can translate those into action and action items. It suggested that we begin as boards to work on telehealth and expansion of medical services as related to the healthcare model in its ever-changing capacity and role, particularly since COVID-19. They suggested that it's good to work on our standards, but we should also be flexible because this area is ever evolving. PACE reported and having, of course, because of telehealth and online continuing ed, as having a record-breaking attendance during this time. Other areas that were discussed were online reviews of their PACE providers and how they perform that. They've established special committees, including a COVID committee and a specialty committee. We went over the difference in exams, that is the SPEC versus EBAS, et cetera, and the appropriate usage of each. We went over how various boards define chiropractic specialties. Uh, Another area that was highlighted was regulatory issues. Under that umbrella, we discussed COVID, temporary permits, licensing complaints, even licensing complaints as it relates to noncompliance with the CDC recommendation or guidelines and mask wearing, et cetera. Fee splitting, telehealth, another area, of course, as I suggested earlier, or as I reported earlier, was management excellence. And there was also a robust presentation on sexual misconduct and understanding definitions of how trauma impacts investigators and biases, and the neurobiology regarding trauma or behind trauma as it relates to trauma. They also spoke about a training that they suggested for their investigators, and the training, I believe, was called Trauma Informed Sexual Assault. And this training was, in their eyes, immensely beneficial for all of their stakeholders, both their commissioners, their investigators, as well as their board members. So it was very enlightening. The next meeting will be at the Hilton West Palm Beach in April of 2021. And again, they are very encouraging with collaborative efforts. And I think that it has been very enlightening and informative participating with them and finding out what other boards across the nation are doing and how we can learn from each other, and as well as make our jobs a little bit easier by implementing and sharing things that implement and improve our productivity, as well as what our goal is in protection of the public. And that's all that I have. I don't know if Dr. Paris has anything. Did I forget anything that you would like to add? I welcome that. And then any questions that anyone has.
I just want to I want to affirm what you said, that I think there's tremendous value for board members to attend these for multiple reasons, and so I'm really happy. Thank you. It was very, very detailed, thorough, and I'm happy you were there, and I hope we continue that into the future. If anybody else has any questions or comments from the board.
I just wanted to also echo what I think Dr. Paris mentioned earlier about some of the getting involved in some of the special subcommittees that they have additionally. I think there's a lot of information that we can glean from that as well.
Any other comments? Any other questions? Okay. Thank you, Dr. McLean. Appreciate that. Sorry we were a little out of order there.
No problem.
And
you're welcome.
so let's go to agenda item number 13. And update, discussion, and possible action on pending rulemaking. And our BCE policy analyst, Andrea McMillan. I think, are you on, Andrea?
Yes, I am. Thank you, Dr. Davis. Good
Thank you.
afternoon. I hope you can hear me. So I'd like to provide an update on our pending regulatory proposals. And I know we just briefly discussed, or not briefly, but we talked about AB 2138. So I'll start off with that one. The agency has reviewed the proposed regulation on the denial of applications, revocation, and suspension of licensure. The package has been returned to the board for revisions. The next step is to submit the package to OAL for notice. So that's where we are with that current file right now. In addition, staff consulted with our regulatory counsel, and we were advised we're not required to move forward with the probation status disclosure regulatory proposal. The reason why is because the statutory language for this regulation is self-executing. So we would not, there was no need to implement a regulation for that reason. And let me know if you have any questions about that. And so I also wanted to discuss what other regulations staff is currently working on. So we are focusing on the CE and curriculum regulations. The CE committee has been working on this through policy issues, and they're been working really hard, and we appreciate that. And then I also wanted to give you an update on the proposal regarding the delegation of authority to the assistant executive officer. Legal Affairs has completed the review for this proposal, and I want to let you know that revisions to the language are being recommended, and we will need to have the board review and approve the language at a future board meeting. Upon approval, this package will be submitted to the executive office for review. And then lastly, our regulatory counsel advised against repealing our regulations on free healthcare events. And I would actually like to defer this item to Mr. Jackson for additional discussion. Mr. Jackson, are you there?
I'm here. I double mute my phone so you all don't have to hear me typing and etc. So on this one, the statutory background for this regulation was extended for a year or two, and then it was not extended past that time. So sponsored free healthcare events is essentially no longer, well, it's not essentially, it's no longer in the statute for the board to use as a procedure for allowing people to have these events. As I'm sure you all know by now, regulations are really hard to put into effect, and they're much easier to get rid of. So the board could take the action of authorizing staff and the regulatory unit to file a Section 100, which would allow the unused language, the surplus language in the board's regulations to go away, and OAL would delete those, repeal those from your regulations. My recommendation is that if this is an arrow that the board would want to have in its quiver, just in case these regulations are reauthorized by the legislature and signed by the governor, then all of us would not have to go through the process that we're going through with AB 2138, for example, because right now it's just extra language. If you remove it, the entire process would have to start all over again. And so my recommendation to the board or to Robert was, why don't we just leave it if the board feels that this would be anything that it would like to take up at a future time? In other words, if the authorizing statute's put back into effect, would this be something that the board would like to do? And if it is, I would recommend just leaving it on your books so that you don't have to spend a year or two putting it back onto your books were it to be deleted and repealed and deleted.
Thank you, Clay. Yeah, that's something that we, assuming, and I trust your counsel on this, Ed, we would still have the authority, because the authority came from a piece of legislation that, if the legislature then reenacted that, there would be a new bill, new chapter number. Would that in any way impact the legitimacy, if you will, of our regulation that we currently have? Because
in my mind, it would. Go on.
No, go ahead. I'm sorry.
In my mind, it would obviously affect the authorities in reference, but if, for example, the new bill just put the previous sections back into effect, then we wouldn't have to do the entire process. And we might be able to even do a Section 100 just to change that, because I don't recall there being any reference to the statute in the bill. Or in the regulation. It's just the regulation text, which runs through all those things.
Okay, yeah, and
this
I
is
agree.
Helen.
Oh, go ahead, Helen.
And just to add, I have done regulations as well. And yes, if it was to change the authority and reference, that would absolutely be a 100 change.
And by the way, authorities in reference are considered non-substantive by OAL, so that would not even require board approval.
That would be great. And, just for the record, that was a very time-consuming regulation, so I wouldn't want to relive that should that be reenacted. And sadly, we never had one request, for participation in a sponsored free healthcare event. And so that was a lot of time and effort for something that ultimately was repealed. And so I wouldn't want to go through that again, so I agree that we should probably just leave it there just in case. Is that something, Clay, that the board could vote on today? Or I guess if they're going to leave it, they wouldn't need to vote on it. What would be the process here?
If you just leave it in the books, there's no vote. And what made me think most about the opinion I gave was right now, all the rules are changing because of COVID. And I can see, even though there never has been a sponsored free healthcare event, we've got a huge need for medical care, and we've got a huge homeless population who would benefit from these type of events. So, and we have a growing homeless population in California. So to get rid of these events seems somewhat backwards when I think we're going to need more in the future, but that's a board decision. But I just couldn't see getting rid of something that I know took you guys probably 2 years to put into effect. So you don't need to do anything.
Okay, any other questions or comments? Thank you, Clay.
You're welcome.
Okay. And Andrea, were you all the way through your report?
Yes, I don't have any other pending regulations that need to be addressed at this time.
Okay, any other questions or comments for Andrea?
Is the board
Okay,
asking for public comment?
No, we're about to. Okay,
Sorry.
That's okay. Thank you, Helen. Hearing no other questions or comments from the board, can we open it up to agenda item 13? Can we open it up to public comment?
All right, this is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this agenda item, please click on that icon with a question mark in a square located at the bottom right-hand corner of your WebEx screen. I'll pause a moment to allow the public time to access that Q&A panel and submit their requests. All right, this is the moderator. Looks like at this time there are no requests for public comment. Would you like me to close that Q&A feature?
Yes, please. Thank you.
All right, the Q&A feature is now closed.
Yeah, problem. Okay, moving on to agenda item 14, review, discussion, and possible action to schedule end-of-year board meeting. And Robert, can you just fill us in on the details of this meeting and I guess estimated time that we would book out for this, or do you anticipate a full day, et cetera?
Gladly. So this would be, the purpose of this meeting would be to conduct hearings with an administrative law judge. We currently have 6 applicants for petition for reinstatement. Not all of those are eligible yet. I mean, there some have submitted applications, but they didn't complete the necessary CE in order to qualify, or they didn't submit their payment. And so, but we'll be reaching out to those individuals. Some of them have been already been vetted. We'll be reaching out to them and letting them know we'll be having a hearing. We also have a continuing education course denial that the providers requested an appeal, and that appeal needs to be presided over by, because it was, sorry, I'm going back. We already conducted an informal conference with the executive officer in which I upheld the appeal, the board's denial, and then they requested a formal hearing before the board, which has to be presided over by an administrative law. So there's that matter, and then there's, I think there was one other matter that's escaping me at the moment, but that would be before an administrative law judge. So so we want to conduct a meeting. The timing of the meeting, it could be a half day. It may be a little more than a half day. In the unlikely event that all 6 applicants wanted to petition, it would likely be a full-day meeting. But, if there's only 2, possibly 3 petitioners, as well as the CE matter, then we could conclude it further. The other matter was there's a decision after non-adopt that the board needs to discuss in closed session, so that would also be held at this meeting. So it's difficult to anticipate exactly how long, but I would encourage the board members to block out the full day just in case it ends up being a lengthy meeting. But as it gets closer, we'll be able to give you a better indication of how long it might be.
Robert, can I ask you, would this...
Go ahead, Dr. McClain.
Would this be just a WebEx conference call, or would there be video possibility as well?
I believe it would just be WebEx. I don't think there's any that's a very good question, actually. I don't think there would be any requirement that we have video, but I'll have to check with the Office of Administrative Hearings on that.
This is legal?
Oh, yeah, thank you, Helen.
Yes, I've actually had other meetings since we've gone into this COVID situation. I do know the ALJs prefer video at that time. It helps them, as well as the board, to assess credibility pursuant to the evidence code, but also it just presents an easier presentation type for the licensee. And so they strongly encourage, just short of requiring, I believe, video conference.
That's why I asked, because I do know that in the past that does assist in evaluating credibility.
This is Sergio Aguilino. I absolutely think we need to do video if we're going to do that. I mean, having served on this board for 8 years, seeing so many hearings, I would say I would vote no against doing just a simple WebEx without having the benefit of looking at body language.
Remember, everybody, that means you have to dress your best and comb your hair.
Only from the waist up.
Correct.
Okay, thank you, Helen. Thanks for your comments, Dr. McClain, Dr. Azzolino. I concur. I agree. I mean, I hope it's required and that we do that. So it looks like on the calendar, the board had highlighted Thursday dates, the 10th, the 17th, and I know in some brief discussions with other board members as to preferred dates for these things, I know the 11th and the 18th are also dates that we might utilize. So I'm not sure how to best open this up for that, except to have people maybe first have us figure out if any of those dates are unavailable.
And just to clarify, the 11th and the 18th are Jewish holidays, and we identify those in case any of the board members wants or needs to recognize a holiday so that it's not overlooked. But that doesn't mean we can't, because those aren't state holidays. So we could have the meeting on those dates if those are dates that work for the board members. And one more thing I'd like to add, I would encourage the board members to lean towards the later date, just because there's going to be quite a few moving parts here. We have to reach out to all of the petitioners and people who wish to be heard, as well as the Office of Administrative Hearings and the Department of Justice, for our Deputy Attorney General. So the more lead time we have, the better it'll be for us. We can probably do the 11th.
Robert, can I ask you a quick question?
Sure.
I'm confused. I just want clarity. We are looking at establishing a singular day, or 2 days.
No, just 1 day. Just one day. It may be a half day or it may be a full day, depending on how many petitioners and so on.
Yeah. So just so maybe I can start off. This is Frank Rufino. The 17 or the week of the 14, 15, and 17 works well for me. It does not work for me the 10th the 11th, or the 9th. So if
Frank,
I,
Frank, does the 18th work also? I heard you say all the way to 17, but not 18.
18 would work as well, yes.
Okay.
So 17, 18, I'm open. Essentially, that whole week of the 14 works for me. The week prior, my only availability is Monday, December the 7th. Then I am booked for the rest of the week.
Okay, great. Thank you. I think our preference would be to do the later dates too, so that's helpful. How about if I can just move through, maybe I'll just go to everybody individually and try and make quick work of this. Dr. Azzolino?
Excuse me. This is Clay.
Yeah.
Just so that we can keep moving forward on the delegation of authority regulation, could we have just say a half hour that day to have that heard at either the beginning or the end or before lunch, so that we could then move forward with that regulation?
Absolutely.
Thank you.
Yeah, no problem. Thank you for moving that forward. Dr. Azzolino, what does the 17th, 18th look like for you?
I can't do the 17th, and I thought we were not going to do the 18th because of the Jewish holiday, but I could do any of the other days. Except for
again, we're not precluded from doing the 18th. It's just if any of the board members wouldn't be able to participate, we just identified in case there's a board member who that date wouldn't work with them because of the Jewish holiday. But it's not an official state holiday.
Well, I cannot do the 17th or 18th. Let me put it that way. I can't do 17th or 18th, or the week of the 21st, 2nd, 23rd. Besides that, I'm open.
Okay.
So 17th to the 23rd, I cannot do. That's easier. Sorry.
Okay.
But the 11th, well, I guess we're...
Well, why don't we go through, I just a suggestion. I mean, if we have 4 members, we would have a quorum and we could conduct this hearing. Because if we're not able to do the hearing in December, we would have to carry it over into January, which I know for a lot of people it would have to be late in January, because for early January there's a lot of pent up business that a lot of people have to deal with, and so those times aren't ideal. So if Dr. Azzolino, if you don't object, and if we do have 4 members who would be able to do one of these dates, we could potentially have the meeting.
And why are we not able to do it on the week before, 17th, the 7th, 9th, 10th, or the 1st, 2nd, 3rd, 4th?
The 11th would really be the earliest, because we need lead time. We need to notify Office of Administrative Hearing to have an administrative law judge participate, as well as court reporter. We need to coordinate with Department of Justice to have our legal counsel. So, okay. And then we need time to reach out to all of the participants to see if to get them to appear on that date. So there's quite a few moving parts. So the more lead time we have, the better. And early December just wouldn't work. It would have, probably the 10th or 11th would be the earliest, and that would be stretching it for us.
Okay. So once again, the 17th through 23rd, I'm out, but I could do any of the other dates.
Okay. So Dr. Azzolino, you could do the 11th, though?
Yeah, absolutely, I can.
Okay, and Mr. Rufino, can you do the 11th?
No.
Oh, okay. So.
Just like you.
Yeah. So Dr. Azzolino, in light of all this, would you object if we have 4 members who can do one of the dates in December? Would
Rufino.
You object to us?
Rufino.
Oh, or Mr. Rufino, whatever, either one.
Why don't we find out what all the other people can do first, and then let's ask that question.
Okay, because if there's four, and not depending on the date, it may be one board member or another. But if we have four, we could move forward if the board member who can't do that date doesn't object. So let's go ahead and find out.
Dr. McLean, what is your tell us what your schedule looks like?
My preference would be, unfortunately, Frank, the 11th. I'm not available on the 18th. So.
Okay, thank you. Dr. Dane, what does your schedule look like?
I could possibly do the 11th. I can't do the 18th. I could do like the 28th or the 29th or the 30th even.
Okay. Dr. Adams, how about you? What does the 11th look like for you?
My preference would be a Thursday. I like the 10th or the 17th, but I can do the 11th or the 18th.
Okay, thank you.
But we don't give him board members any say on anything, do we?
I remember that. Okay, well, my preference would be the 11th. Looking at what that's something that would get us a quorum and have at least four of us there. I would just want to reconfirm with everybody that's okay, and also Mr. Ruffino that you would be okay with us going with the quorum on that date.
Yes, I'm okay with it, but unfortunately, there's no way that I can make it work because I have another board meeting already scheduled for the 10th and the 11th. So I'm okay with you guys going forward. Just understand that I won't be able to. But then, other than those 2 days, then as I said, the week of the 14th would work. And Dr. Dan just mentioned even after the holiday, that would work as well. Either the 28th or the 29th or the 30th. Just want to put it out there. That would work for me as well.
Okay, thank you. Well, I mean, I think we could consider other dates. I know that weekend between with New Year's and Christmas falling on Friday to a Friday, it's a vacation weekend, a week actually. Yeah. So if I could, and thank you, Mr. Ruffino, for being so flexible and allowing us to move forward. If I could recommend, maybe we snatch up the 11th. I know it's never ideal. I think we all know that by now. Is anybody not in agreement with that? Okay. Well, let's go ahead and calendar the 11th. Do we need a motion for that? We do not need a motion, I'm hearing. So let's go ahead and we'll have them schedule the 11th.
And Dr. Paris, I just want to reiterate to the board that we haven't yet reached out to the Office of Administrative Law, and so this is just tentative, and we'll send a confirmation to you all as soon as we lock this in, because we still have to reach out and make sure that their schedule can accommodate this meeting request.
Okay. Can I just chime in a little something? If the OAL isn't able to make that date, the 11th, work, I personally would prefer that we did not go to the last week in December because of the vacation. That we just move it to January at that point if the rest of the parties are not available for that day, and then that way we can also maybe include Mr. Ruffino.
Surely, yes.
And just one minor glitch. There's been so many anomalies. If we do have to move it into January, the CE course appeal, we do have a time frame. So unless the appellants, I guess, agree, we would have to hold the hearing for them in December, and so we might have to have like a very brief meeting with an ALJ to hold that appeal hearing, unless we are able to, if we ask the CE provider that's appealing, if they would be willing to wait until January. So just want to put that out there. But we'll do our best to, hopefully this will all work out for the 11th and none of us will be an issue. Thank you, everyone.
Okay.
Real quick, this is Lawrence. Not to monkey this up too much, but I would not be available at the end of January in the event that it does have to get moved. There was an earlier comment that something might have to get moved to the end of January if we weren't able to meet these dates.
Okay. Yeah, so thank you for that. I think that moves us kind of into the agenda item 15, which is looking at the proposed 2021 board meeting schedule. And I think if, let me know what you all think of this. I would like us to really take this home and let us send out an email. You can reply by email or by doodle poll, and we'll send a few dates here. Everyone can see the suggested dates are January. It's essentially the last Thursday of every month, of the months we have meetings. So January, April, July, and October. And those are all, and Dr. Adams just mentioned the end of January doesn't work for him. So it's clear already we're going to have to negotiate some dates for all of these. I think we have a little time for January. Robert,
Yeah.
Is that okay? We have time to doodle poll it and send an email?
Yeah, we can, we'll just have to, whenever we decide a date, we just have to give ourselves 10 days to notice the meeting. So we may have to, it's less than ideal, but if we're not able to schedule everybody for a full board meeting in January, we'll have to at least have a very brief meeting to conduct election of officers because the act mandates that occur in January.
So and there's, Robert, there's 2 weeks blocked out as conflicts, early January, from the 4th to the 8th and the 11th to the 15th. I don't recall.
That may be remaining from last year. I think that might have been the time that you went on your vacation, Robert, last year, and so that might have just been something held over for the person that put the packet together from last year.
Okay. Yeah, and I think if I'm recalling, I think I discussed this with Amanda, who put this together, and we were thinking that right after the holidays is less than ideal, and so we were looking to try to schedule a meeting for later in the month, but we can schedule something earlier if those dates work for the board members. I'm not going anywhere in January, so if it works for all the board members, then those dates are fair game.
Hi, this is Lawrence. Just want to let you know, I do have my exact dates for January. I will be unavailable the 21st to the 24th of January 2021.
Oh, 21 to the 24th. Okay, so
that's only 2 weekdays, so that's not bad at all.
Okay. So does anyone have any suggestion, comment, or disagreement with that we look at these dates that are proposed? And as I said, it's the last Thursday of January, the 28th, April 29th, last Thursday of July, the 29th, last Thursday of October, the 28th, and then obviously focus more on January so we can get that one set first and at least respond back to us. We'll give everyone a week or so to look at that. And if you have alternative dates, probably the closer we can be to the proposed date, I think the better off we'd be. And I think it'd be a little more efficient for us to do that. It might take us till next week to arrange.
Yeah, and in the meantime, I'd ask the board members and legal counsel, anybody that would need to participate in the meeting, if you have any blackout dates around those times that we've identified, if you can send me a quick email and let me know that you absolutely cannot do a certain date. This way, it'll help us focus and do the poll.
Any comments, suggestions on that?
So yes, Mr. Chair, real quick, this is Rufino. I know that we keep mentioning Thursdays, and I know that might be a preferred day. Is that a preferred day, whether it's the last of the month? Because I do have a conflict in January, for example, that Thursday will not work. but the Wednesday, the preceding, like the 25th, 26th, or 27th, or could work. Or if it's just Thursdays that we're looking, then January the 7th would work. So I'm just curious, is this Thursday? Are we adopting like Thursday as the board day? And
No, I actually,
hope not.
I did not highlight those. Thursdays actually aren't the best day for me either.
I'm sorry to interrupt, Dave, but just Thursdays, historically, I've been with the board for 11 years, and it seemed like Thursdays were always the best days for the board members, the licensee board members in particular. I noticed Dr. Adams mentioned earlier that Thursdays are best for him. It seemed to be something unique to the profession where Thursdays were a good day, but it really it's what's best for the sitting board. So if the current board members, if collectively Fridays or Wednesdays are better, then there's no dates that it has to be.
Mr. Fino, if it's okay, why don't we send out the email and the doodle poll, and then I would suggest that if there's a date that people can't do, we just send back your alternatives as close to that date as possible, and then we can work through some quick email back and forth to figure that out with everybody, and maybe use the doodle poll to send out a couple options that might everybody might have available.
Sure.
Okay, thank you. Okay. So I don't think we need a motion to have you send out an email doodle poll.
No.
Right? Okay, good.
Let me, Helen, is public comment necessary on this?
I'm not sure what the public could comment on as to the board's availability, but of course it never hurts to ask.
Okay, moderator, let's open it up for a public comment, and let's make sure we don't have any. They may have a preference as to hey, it's their meeting. It's not our meeting, it's their meeting.
All right, this is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this agenda item, please click on the icon with a question mark within a square located at the bottom right-hand corner of your WebEx screen. I'll go ahead and pause a moment to give you time to access that Q&A panel and submit your requests.
And it's as long as we have it open, if there are any public comment for items not on the agenda, we could also take those now too. Agenda item number 16.
All right, this is the moderator. Looks like there are no requests for public comment. Would you like me to close that Q&A panel?
Please, thank you.
All right, Q&A panel is now closed.
Okay, agenda item number 17. Any future agenda items?
I don't know that this is necessarily a future agenda item, but it's just a procedural thing. I have a couple of comments or requests, I guess I should say. One is that is it possible for staff to, when drafting the materials for the meetings, is it possible for us to have the packet numbered all the way through so that it makes it easier for referencing back and forth, or like when Mr. Jackson was referring to certain specific details, that we could just easily reference the page number 105 instead? And number two is it also possible for us to list, I don't know that it's not already done. This might already be done. List next to the what am I trying to say? Next to the areas in the agenda of who is making the presentation, for an example, when it's staff such as Dixie is going to be covering item number 7, if we could just reference that, so that when we look back, we will know who to ask questions from, or who was in charge of that, et cetera, et cetera. And also with just thinking about referring back to many months ago of board packets or committee packets, it's very helpful if we know who the players were. For an example, in the subcommittees, it would be helpful if we had also, like it's done, I think, in this packet, if we had a list of those who made comments or those who attended those meetings, specifically who participated, I should say. So the participants and their title or their organization that they're related to, particularly in light of the correspondence that we had at this past committee meeting, whereas I wrote down a lot of that information, but it just would be helpful for that to be a part of the packet, the next packet, or I think that's it.
Those are all reasonable requests, and so and I plan on meeting with staff following this meeting to discuss feedback about the board meeting packets and try to, figure out how to incorporate the changes requested, and certainly putting the page numbers and identifying the people who are presenting information, definitely be able to do those. As far as the referencing who participated in a meeting, if somebody commented, or made any kind of comment or participated in discussion, they would be identified in the minutes. Otherwise, we typically don't identify people who attended a meeting, unless they stepped up and identified themselves. So are you requesting that, or just that whoever made comments, that we identify them and their comments?
Sorry. I think more so whoever, I know that in the general meeting, in the minutes, that if someone made a comment, they are identified in the comments, but what can we do in the subcommittee so that when we look back at our notes there, that we could have something similar, because we don't really have minutes on the subcommittee.
Hey, hello, Dr. McLean. This is Natalie Boyer. We do have committee meeting minutes, and when a member of the public speaks, they are identified in their title. So, for example, September, when we all met, we will review those minutes at the upcoming November meeting.
You're right. I'm sorry, I misspoke. We do have
okay.
committee draft of the minutes from the committees, but I'm trying
but
to
those aren't
look
included in the board meeting minutes? Is that what I mean? In the so
only in the committee packet.
So that's we don't include that in the materials for the board meeting, the committee meeting minutes, and those haven't even been approved by the committee yet. So that's a discussion. I'll have to look into that and see how we can do that.
You're right. If they haven't been approved, I understand the task there. It just, in the general meeting minutes, I'm thinking more so those who made who were referred to in the minutes, if in the committee, let me get this straight. So those who made comments or brought forth information in the committee, if we also had those names and where they came from, as far as if they were just a professional member or a professional provider or from an organization, if we could have that as well available for the general meeting in the summary or some type. I don't know. Just a little suggestion if it's possible. If not, I understand.
Well, I'll discuss that. Thank you, Dr. McLean. I'll discuss that with the staff, and then we'll follow up with you we'll discuss what the possibilities are, and then follow up with you and try to figure out what we can do for future board meetings.
Great, thank you.
Okay, any other future agenda items? Anyone on the board?
Mr. Chair, this is Rufino. It's not a future agenda item, but I have a question regarding sunset review. And probably Robert will know offhand. I know that they're being postponed. Are we due for sunset review next year, Robert, or is that?
Yes, we would have been previously, pre-COVID, our sunset review report would have been due to the legislature at the end of this year, about now, and our hearing before the legislature would be in the spring of 2021. However, we've been put off a year. So now our report will be due at the end of 2021, and our hearing before the legislature will be in the spring of 2022.
Okay, that makes sense, because I was looking through my notes and I couldn't figure out. I go, well, I was wondering, I figured it was not on the agenda, and I figured such, but I was not sure. So thank you for confirming. And of course, I will be not worrying about it. That's all yours, Robert. I will not be attending.
Yeah, you'll just be listening in on the meetings from the beach somewhere.
Yeah. All right, thank you.
Okay, on the agenda, I show a 15-minute break, and are we going? We have closed session, and if it is okay with everybody on the board, can we take 5 minutes and potty break and come back at 3 o'clock for closed session?
Sounds good to me.
Does anybody need 5 minutes? Can we check, Dave, and see if they need 5 minutes, or can we go right into closed session?
Yeah, sure. Right. Does anybody need 5 minutes? If not, we'll just move right into closed session.
This is legal. I would suggest we go ahead and take 5 minutes to make sure the moderator can excuse any public persons or whatnot, and be prepared for the closed session.
Yeah, thank you, Helen. Okay, let's take 5 minutes. We'll come back at that'll be 6 minutes. We'll come back at 3 o'clock, and we'll be in closed session.
And just to clarify for the public, the public portion of the meeting is over, so there'll be no further public discussion, so there's no need to hang on the line or report back.